Okay, good afternoon, everybody. We'll let everybody get a chance to sign in. We'll give it a minute or two, and then we'll get started. And just so everybody's aware, there is a Q&A function in here. So if there's anything that I'm talking about that you have a specific question regarding, fire a question in there, and I'll try and get them as we're going through. But if not, there'll be plenty of time at the end to go over everything. Okay, let's get started. Good afternoon, everybody. My name is Dillon Brown. I'm a partner here at Marcus Arico, Emmer and Brooks, and my practice is twofold. I represent general representation for condominium associations, but then a large part of my practice is also handling landlord-tenant law, and I run most of the landlord-tenant department here at the firm. So I'm representing landlords, both residential and commercial, in all phases of lease enforcement, all phases of the eviction process, to and from housing court. So that's some of the broad level things that we're going to be talking about today. I wanted to talk and name this webinar Landlord 101 because it's really high level things that your typical landlord and your property manager should be aware of. And what should be noted too is that this webinar is specifically going to talk about tenancies with respect to both residential and commercial, but within the state of Massachusetts. However, the concepts here likely do apply in New Hampshire and other states. So if there's specific questions regarding those states, I might not have a specific statutory response to that, but we're going to be able to move you in the right direction. So let's get started here. Okay, at a very broad level, when you're talking about landlord tenant, you're talking about three different types of tenancies. The first tenancy is a fixed term tenancy. So that means that the tenancy is for a fixed period of time. Typically, in your residential context, that's going to be for a year. So if a lease agreement were to start on December 1st, it would go for a year and expire at the last day of November at the end of that year. So typically for a 12-month term. Commercial tenancies, those are typically a bit longer. It'd be pretty rare to see a commercial lease agreement for 1 year, but it does happen. Typically, it's for a lease term of 5 or 10 years with lots of options to renew, meaning that the lease agreement, so long as the tenant's in compliance, could renew for, another 5 year term, 10-year term, whatever the terms dictate. But ultimately, what's really, important to understand here is that if you're dealing with a fixed term tenancy, that means you have a tenancy that's created and subject to the terms of a lease agreement. If you don't, then you are likely falling into the category of a tenancy at will. So a tenancy at will is a month-to-month tenancy, or whereby the landlord rents the apartment or the commercial space to the tenant for a rental period by rental period, and that's typically a month-to-month tenancy. These are typically created when the landlord and the tenant don't have a lease agreement, or there's an oral or a handshake written agreement between the parties. Essentially, landlord and tenant agree that, hey, you can stay in unit 5, rent's going to be $2,000 a month. I don't have a lease agreement. You're just going to pay me every month. So if that's the case, what happens by operation of law is that tenancy is constitutes in what's referred to as, again, a tenancy at will. It's a month-to-month tenancy, so it's a default tenancy where there is no lease agreement and you're just going to go month to month from there on out. Um, a tenancy at will can also be created if you have a lease agreement that expires and then the tenant doesn't vacate, but the tenant continues to pay rent and the landlord accepts rent. Therefore, by operation of law, because the lease has expired, but everybody's acting by the same terms, meaning that, tenant continues to pay rent, tenant continues to comply with the terms of their originally, although expired lease agreement, again, by operation of law, a tenancy at will has been created. We'll talk about termination of tenancies in the next slide or so, but tenancies at will is where either a landlord or a tenant to that tenancy can terminate it on a full rental period's notice. There is one caveat to that, and that's in a context where a tenant isn't required to pay rent. This typically comes up in a family context where family owns a property, they have a family member or somebody close to them that they allow to stay there, and they're because of that good relationship, although that relationship may sour, there's no requirement to pay rent. And in situations like this, there's a statute which provides that essentially that it would take 3 months in order to ask that tenant to leave. So they're entitled to 90 days notice as opposed to a traditional full rental period. Um, Last type of tenancy is a tenant at sufferance. These are holdover tenants. It's when a tenant fails to vacate the premises upon expiration of their lease term and no rental payments or no use and occupancy payments are tendered. They're a holdover. Essentially they're staying there for free. And what the law says is that tenants at sufferance or holdovers aren't entitled to a notice to quit to terminate their tenancies, but typically in our practice, look, if we're going to be running into court to asking a holdover tenant or a squatter essentially to vacate, we want some notice to them. Judge is going to want to see that we tried and did our best to get them to vacate voluntarily before we filed an action in the housing court to get them out. So in those situations, I typically send something along the lines of a 72-hour, 48-hour notice to vacate, which essentially says that, look, you're either staying here without the permission of the landlord or you're staying here past your lease expiration date and you haven't paid anything and your tenancy it essentially is expired. So you no longer have occupancy rights. So we're asking you to leave by that time. And if they don't, ultimately, again, which we'll get into, you're going to need a court order to get them to vacate. So termination of tenancies. This is when we're referring to a notice to quit. So in order to terminate a tenancy for non-payment of rent, the landlord needs to serve the tenant with what's referred to as a 14-day notice to quit, which says that essentially the landlord is notifying the tenant that, look, we're terminating your tenancy as a result of your persistent failure to pay rent in full and on time in accordance with the terms of your lease agreement. So what the tenant is required to do in that situations is that unless the rental balance is satisfied in full or they vacate the premises within that 14-day period, then the landlord, upon that, essentially, if they don't pay rent, they don't vacate within 14 days, the landlord's got a right to commence an eviction proceeding in the housing court and the district court to regain possession of the premises. Notice to quits are really important. This goes for non-payment, for cause evictions, or terminations of tenancy at will. And it's because the terms need to comply with the statute. And if there's any holes in that, tenants can raise that as a defense. And if the notice to quit is rendered defective, then it could result in a dismissal of an eviction case, meaning landlord in our office is going to start the process all over again. So one of those is that if you're terminating a tenancy for non-payment of rent through service of a 14-day notice to quit, you need to include some statutory language in there. And I've included the text here. It comes right from 186, Section 12. And essentially what it's saying is that, kind of what I referred to earlier, is that, look, you have a time period in which to satisfy the outstanding rental balance that's owed to the landlord. And what that statute says is that if you as a tenant haven't received a notice to quit for non-payment of rent within the past year, then you have a right to cure and satisfy this balance in full within 10 days in order to cure your tenancy. And you're probably thinking, doesn't that contradict what Dillon just said in that case? And it's true. If a tenant has received multiple notices to quit for non-payment of rent and the rental balance is satisfied in full, doesn't that, go against what's that saying? They only had one chance to do that within that time period. And the answer is that if we're in housing court in front of a judge on a non-payment case, it's a much harder argument for a landlord to make that, look, I know that we terminated their tenancy for non-payment of rent and that balance has been paid in full. Then the judge is going to look at the landlord in that case, says, well, you've been made full. That notice to quit has been cured, and they're going to have a strong argument that to dismiss the case from there out. So if you're proceeding on a eviction for non-payment of rent due to multiple instances of non-payment, you still have an argument based on that statute, but it's going to be a lot easier for a landlord to evict a tenant if there's currently a balance at the time that we're running into court. Okay, so that's non-payment. The other, very, very typical lease termination or termination of tenancy is for cause. evictions or, conduct of the tenant that violates the terms of their lease agreement. So what the statute says is that you need a 30-day notice to quit in order to terminate that tenancy. It's actually a full rental periods notice. A lot of landlords refer to it as 30 days because the statute says it's 30 days or a rental period or whichever is longer. So in that notice to quit, you need to notify the tenant as the basis of your terminating their tenancy. Essentially, what did they do on the property or what have they done or failed to do in the apartment that warrants their removal from the premises prior to the expiration of their lease term. And unlike non-payment of rent, this is a pretty high bar that you need to reach. We're talking about criminal conduct, extreme nuisances, arrests, it could be drug behavior, which we'll talk about for a second. But again, like the non-payment case, for cause violations have an opportunity to cure. So we can terminate the tenancy based on material misconduct, but if they cure that violation, if they make a repair or they stop doing what they're doing, then the landlord again may have a tough argument in which to go in and ask a judge to evict them based on the conduct that they've said. So what we advise landlords and property managers all the time is that if we're going in on a for cause eviction for a lease violation, it better be extremely detrimental to the property, detrimental to the other residents, because that's what a judge is going to want to see in order to ask that tenant to vacate the premises. The other termination tenancies are non-renewals or terminations of a tenancy at will. Again, if a landlord decides not to rent to a tenant beyond the expiration of their lease term, their lease is going to say that they need to be notified that their tenancy is not going to be renewed. And we advise landlords and property managers to send out that notice of non-renewal. Typically, a lease agreement will say 60 days or 30 days notice, which essentially you're letting the tenant know that, look, the landlord is exercising the right to not renew your tenancy for another term. So that means you need to vacate at the end of your tenancy or the end of that 12-month period or whatever the lease term is. And if they don't, the landlord can use that notice of non-renewal of tenancy as the notice to quit to commence a summary process action, which again, we'll talk about how we're going to go about commencing that. Same goes for the terminations of tenancies at will. Again, either party to a tenancy at will, meaning landlord or tenant, can terminate that tenancy on a full rental period's notice. You can do so for any non-discriminatory reason. It could be based on a business judgment decision. It could be that you want to increase the rent. It could be that you want to rent to somebody else. So long it's not a discriminatory basis, the landlord can simply elect to terminate a tenancy at will on a full rental period's notice, and we would do that through a notice to quit for termination of tenancy at will. And if they fail to vacate by that time, a full rental period later, the landlord's going to have the right to commence an eviction to regain possession. This is where I was talking about. So this is what I refer to as the drug eviction statute. It's chapter 139, section 19 and 20. And this is the type of conduct that we're really talking about on a for cause eviction. But if it falls under one of these categories, but by statute, you could bypass that 30-day notice to quit and waiting a full rental period to get them out. So what chapter 139, section 19 says is that if a tenant is using or occupying a building, an apartment complex, essentially any sort of rental property for prostitution, lewdness, gaming, illegal sale of alcohol, weapons, drugs, keeping of illegal weapons, then the landlord can void the lease agreement entirely and seek a court order to evict them. If you're doing this, then this is raising to that level, to that high bar in which a landlord's got to meet to convince a judge that this tenant needs to leave the property immediately. And again, in order to bypass that 30-day notice to quit requirement for a for cause eviction, it has to fall under one of these categories. And if landlords or property managers are coming us asking us to exercise, termination of tenancy based on this, we're going to need a police report, something along those lines, which substantiates that the tenant was either arrested or convicted of one of these things. And if that's the case, then we can get a hearing quickly in front of the judge to get that tenant removed from the property. And we've had success doing that. But again, I had a police report going in where it rises to this level of noncompliance. The second part of that statute, section 20, is landlords can be subject to liability to this. So if a landlord knowingly lets the premises owned by them or under his control for the use of those things, prostitution, lewdness, illegal gaming, sale of alcohol, drugs, keeping of a weapon, then if the landlord doesn't take the action to exercise their rights under Section 19, meaning that if the landlord doesn't terminate the tenancy and seek an immediate removal from that tenant, they could be subject to fines and possibly imprisonment for liability. This comes up in the condominium context a lot. So this is kind of where my practices overlap. Oftentimes, boards and associations of property managers have a unit where the owner rents it to the tenant, and then the tenant is convicted or arrested for one of these categories, manufacturing, selling drugs out of the unit being a common example. So in those cases, we've made demands upon the owner successfully saying that your tenant was convicted of this crime, including, for example, manufacture and sale of drugs out of the unit. They were arrested on condominium property. We're demanding that you exercise your rights under Section 139, Section 19 to remove that tenant from the premises. And we've been very successful doing that. The owner complies, they engage their own attorney, and they're in front of a judge within a matter of days and even a week to get that tenant removed from the property. So super useful tactic that landlords can rely upon. But again, it's got to meet this high bar as to one of those crimes. So if the landlord has terminated the tenancy through a notice to quit for non-payment, foreclause, lease violations, termination tenancy at will, non-renewals, and the tenant fails to comply, meaning that they either didn't pay the rent that they were supposed to be owed or vacate the premises by the time they were supposed to, then the landlord would then have to commence what's called a summary process eviction proceeding in the housing court or either the district court to get a court order to authorize the removal of the tenant from the premises. And this all falls under the premise that there's no self-help evictions. Landlords are prohibited from going in and removing the tenant themselves. As much as you probably want to do that in a lot of cases, you can't change the locks and kick them out. You need a court order to do that, and you do so through a summary process action. So again, there's a specific court. It's the housing court, which is a district of the trial court, which specializes in eviction proceedings. So these are judges that typically practice the same type of law that I practice right now, and they only deal with housing and tenancy in eviction matters. So I strongly recommend, if this is a residential tenancy, that you file in the housing court because you're going to be dealing with people who know exactly what's going on. This isn't their first time dealing with an eviction, so you get a judge and a court staff who is well versed in this area of the law. If you have a commercial eviction, you obviously can't filing in the housing court because it's not a residential property, so you'd be filing in district court. One thing I wanted to note is that another reason that I file in the housing court is, again, if we're dealing with an eviction, landlords are going to want to move as quickly as possible in order to remove a tenant from the apartment or from the premises. And there's a statute that actually allows a tenant, if a summary process action is filed in district court, to automatically transfer it to the housing court. So again, if we want to move as quickly as possible, then I suggest that we file in the housing court. Ultimately, in a summary process action, what you need to prove is that the tenancy was properly terminated and that you're entitled, as a matter of law, to regain possession of the premises. So again, in a non-payment of rent case, we need to show the judge that there's an outstanding rental balance that wasn't satisfied in accordance with the terms of your lease agreement, and that a 14-day notice to quit was served and the tenants failed to comply. Same thing goes for lease violations. Again, this is the higher bar that we're talking about here. You need to show the judge that a notice to quit, a 30-day notice to quit was served on the tenants, and it details the basis of which you need to evict the tenant, or what did they do on the property that warrants their immediate removal. And then you need to prove that, number one, that issue or that lease violation is still very prevalent within the community and that they failed to cure it or they failed to stop what they're doing. Same thing goes for non-renewals of tenancies and terminations of tenancy at will. Pretty simple. That the tenancy was non-renewed or their tenancy at will was terminated and they failed to vacate by that time. But ultimately, prior to COVID, summary process actions were all, you got one court event. Everything was heard on one day. So essentially, landlords and their property managers and the tenants would show up to court at 9 a.m. and there'd be a huge list of cases. I'm talking hundreds on, all doing the same thing for on that day. So what the court staff would do is that they'd send you to mediation. with housing court specialists who are court appointed mediators who attempt to see if the parties can reach some sort of agreement instead of going in front of the judge. But in response to COVID and the backlog of evictions that piled up during that process, they switched this to a two-court event process. So you're still going through the mediation of the trial process. They're just going to be heard on two separate dates. So the first, again, is that housing specialist status conference. It's mandatory mediation between the parties where they meet again with this court-appointed mediator to see if they can essentially come to an agreement instead of waiting in court and trying to get in front of a judge. And these are incredibly useful and incredibly tactful. I'd say that 95% of my cases are handled through mediation, and the parties are entering into what's called an agreement for judgment. An agreement for judgment is essentially a settlement agreement that is filed with the court and amounts to a court order. But the beautiful thing about an agreement for judgment is that instead of litigating a case in front of a judge and having a summary process trial, which is that second event, where a judge issues the decision based on what the judge feels is appropriate in that case, for an agreement for judgment, you get to control what those terms are. So in a non-payment case, we could enter into a payment plan agreement with the tenant that amounts to a court order, meaning that, you know, as a judgment, that landlord gets possession of the apartment, but your ability to evict them through the issuance of an execution, which is what we'll talk about in a minute, it's how you remove the tenant for the premises. The landlord's ability to do that is stayed pending that the tenant agrees to certain conditions, meaning paying the rent on time for the duration of their tenancy and then paying off the portion of the balance that's owed based on the payment plan agreement. And if they fail to adhere to that, then that's a breach of the agreement for judgment, and we're going to be able to get that court order to remove the tenant from the premises without even having to go in front of the judge to litigate a summary process trial. So again, super useful tactic. It cuts time, it cuts money, and you're getting terms that you're ultimately okay with rather than rolling the dice and getting in front of a judge and having them issue a decision for you. Ultimately, again, the goal in any summary process action is to secure a judgment for two things. You want possession of the apartment and you want the outstanding rental balance. Okay, so emergency rental assistance, they again, in response to COVID, such housing court and summary process actions really changed after the pandemic. And a statute was passed which said that due to the backlog of evictions and tenants being unable to afford to pay their rent. And so in order to address that, a statute was passed which says that if you're a tenant that's being evicted for non-payment of rent and you have a pending, it has to be an open application for emergency rental assistance, then the court has to do a number of things. Essentially, you can't be evicted until that application for emergency rental assistance has been processed. So that means that if there's a summary process trial that's been scheduled in front of a judge, it's going to be continued. And that means that you can't have a judgment enter against you as a tenant for possession of the premises if you have a pending raft application. And if there's an execution that has been pending or that has been issued, then the landlord can't levy upon it, or the landlord can't proceed with the eviction if there's a pending raft application at that time due to non-payment of rent. So the most popular subsidy provider or the organization that provides this emergency rental assistance is a state program known as the Residential Assistance for Family and Transition Program, and it's the RAF program. And what RAF does, and they receive funding from all over the state and other organizations, is that they provide tenants with up to $7,000 worth of emergency rental assistance within a 365, 12-month calendar period, which means that by the time the first assistance is issued to that tenant, they can't get more than $7,000 within a 12-month period. So if in the first application they get $4,000 and then we're doing this dance again 6 months down the line, they're only entitled to another $3,000. So it's useful as a temporary band-aid to get a tenant back on track and avoid an eviction, making the landlord whole. And again, the primary purpose of raft is to preserve tenancies. So it satisfies outstanding rental balance. But what raft can also do is give tenants the ability to vacate the premises and move on to a new tenancy. So raft will also provide rental assistance for first month's, last month's, and security deposit for their new tenancy. What's also important to note is that in order for a landlord to receive emergency rental assistance through LAFT, both the landlord and the tenant got to complete applications. So that means that as soon as the tenant applies, they're going to give RAFT the landlord's contact information, and RAFT is going to reach out to the landlord or the property manager and ask for a bunch of information. Proof of ownership, so you send them a deed. Proof that the tenancy was terminated, you send them the notice to quit. And ultimately, what they want to know is what is the outstanding rental balance. So property managers and landlords need to have a rental ledger that they're able to send to RAFT so that they confirm that this tenant is number one, entitled to rental assistance, and they need to know what that outstanding balance is at the end of the day. Again, what's super important when we're dealing about non-payment of rent cases, again, is that $7,000 is the cap. So Raft won't fund more than $7,000 or issue any rental assistance at all if the tenant has an outstanding balance that exceeds $7,000, unless the parties enter into a repayment plan agreement for the remainder, meaning that if the outstanding rental balance is $10,000, Raft, if the tenant is approved, will fund the 7,000, but they're not going to put good money towards bad if the landlord's just going to proceed with the eviction anyway. So they want a written agreement between the landlord and the tenant as to a repayment plan for that remaining $3,000. So this is super important because, again, there's that statute which prohibits judgments from entering against tenants if there's a pending raft application. So in order to speed up the process, one of the tactics that I use is that we enter into stipulations with tenants during summary process eviction proceedings. It's not a judgment, so it doesn't violate the statute, but essentially what it says is that we're acknowledging that the tenant has applied for RAP and they're entitled up to $7,000. So we're going to enter into a payment plan agreement now, which funds that remainder of $3,000. However, there's going to be a provision in that stipulation which says that if for some reason your RAFT application is denied, or for some reason you don't pay that remaining $3,000, we're going to have the right to file and seek the execution to remove you from the premises. So there's ways that you can bypass that statute regarding pending RAFT applications, but you have to be diligent in responding to RAFT and getting, the paperwork in place where that balance can be funded. And that's because under the Massachusetts discrimination statute, which is Chapter 151B, a landlord's refusal to accept rental assistance or comply with RAF's application process could be considered discrimination because tenants are entitled to rental assistance, and there's case law out there which could subject a landlord to liability. So when we're in housing court, oftentimes what tenants will do is they'll go to free legal aid. It's resources that are applied for tenants that give them defenses or legal assistance in, opposing the landlord's right to eviction. And there's primarily three main arguments that I see time and time again. The first is the rent withholding statute. So in Massachusetts, there's what's referred to as the implied warranty of habitability, which means that the landlord needs to maintain the premises in a clean and sanitary condition, and the tenant's entitled to that. Essentially, the apartment and the building need to adhere to the sanitary code. And if it doesn't, then the tenant can withhold rent, which gives them a defense to both a non-payment case as well as a no-fault eviction. So we're talking about a termination of a tenancy at will and a non-renewal of tenancy. And what the landlord has to prove, or sorry, what the tenant has to prove in that case is that the landlord knew of the uninhabitable conditions, the tenant didn't cause them, this isn't a hotel or a motel, and the premises or the apartment doesn't need to be vacated in order for the landlord to make the requisite repairs. So, especially in a non-payment case, if the tenant's claim of withholding rent is greater than the outstanding rental balance, meaning, the value of the apartment that they got is greater, then tenant wins the case because their claim would defeat the landlord. However, if the tenant's claim is less meaning that their ability to withhold rent either wasn't substantiated or they weren't entitled to hold that much rent based on the use and occupancy if they had of their apartment, then the landlord would prevail should a judge agree with them, but there's a 7 day cure period. So the tenant could satisfy the outstanding balance within 7 days after that time, and landlord's cured, case would be dismissed, or judgment would enter, essentially allowing the tenant to stay so long as that balance is satisfied in full. And that's why before I'm filing a summary process action, um, what we're going to be doing is reaching out to the landlord or the property manager to make sure that there are no repairs that are outstanding, because again, it's a great defense that tenants can raise to oppose any sort of eviction. So what we want is copies of work orders which shows that the things that the tenant is complaining of have been completed. So if the shower drain's not draining, we have a work order from October 5th which says that that it was reported, it was handled by our maintenance staff, and that the shower drain has been repaired. So we want details backing up all the repairs that have been made to the apartment, because it can prevent a tenant from prevailing on a rent withholding claim. The second most common defense tenants raise has to do with retaliation. There's a statute again in Massachusetts. There's two of them actually. So this is pretty prevalent for tenants to raise. So it's 186 section 18 and 239 section 2A. And what it says is that if a tenant receives a notice to quit or their tenancy is terminated within 6 months after a tenant exercising a legal right with respect to their tenancy or raising some sort of defenses to their landlord with respect to that tenancy, it creates a rebuttable presumption of retaliation. And if retaliation is made in that case, it can defeat a landlord's claim for eviction. Essentially, what the tenant is arguing is that the only reason that the landlord is evicting me is because I asked them to make repairs, or I notified the Board of Health about these certain issues in the apartment, and they just don't want to pay it, so they'd rather evict me instead. That's essentially the retaliation argument. So again, it's a rebuttable presumption of retaliation. So in order to rebut the argument that, hey, as a landlord, I'm evicting you because you're raising all these concerns and I just want to deal to it. A landlord needs to prove two things: that they have an independent justification for eviction, and that the eviction would have been commenced at the same time in the same manner. Perfect example of that is a tenant is being evicted for non-payment of rent, and they've owed rent for 3 or 4 months. Landlord couldn't take it anymore, sent the notice to quit, and ultimately filed a summary process action. While all that was going on, say after the notice to quit, tenant runs to Board of Health and makes all these complaints. And then they argue that, look, because I filed this complaint with the Board of Health, because I exercised a legal right, they're now retaliating against me by proceeding with this eviction. And case law says that so long as, again, there's an independent justification for eviction, non-payment of rent in this case, the landlord can still prevail and rebut that retaliation, because the landlord has an independent justification, meaning the tenant failed to pay rent, and therefore I would have commenced this summary process action anyway in the same time, in the same manner. I was never going to let this go past 3 or 4 months, and until I'm paid in full, we're going full steam ahead. So, I mean, those are the two big ones. Another one that tenants will raise is violation of the security deposit and last month's rent processing statute, which we'll talk about later on. And again, it's super, super important that if a landlord is collecting last month's rent and a security deposit, that they comply with what the law says, 18615B, which we'll talk about. And that's because that failure to adhere to that, number one, gives the tenant a great argument to defeat a landlord's claim in an eviction, but it can also subject a landlord to liability under the Massachusetts Consumer Protection Statute, which entitles the tenant to triple damages plus attorney's fees. So we'll talk about that in a little bit. But, the goal of any summary process action, or the goal of terminating a tenancy, is almost always that we want to get the tenant out of there, that we want to remove them from the apartment. And again, you can't do so without a court order. And that court order that we're looking for is referred to as an execution. So if the landlord wins a case, then they're going to request that the judge in the clerk's office issue an execution, which again is a court order that's given to a constable that authorizes the physical eviction of the tenant from the premises. Again, it's got to be served by sheriff, it's got to be served by constable, and you need to serve it at the apartment. In-hand service isn't required in this case. all the housing court really wants to see is that the notice to quit was served by an independent third party that's licensed by the court. So that's a constable, that's a sheriff, and that it's served at the apartment. And, sometimes because tenants vacate or sometimes tenants don't answer the door, then in-hand service is not required. And when the execution is ultimately served, the constable is also serving what's called a 48-hour notice, and that's a requirement under the statute. Essentially, what that 48-hour notice says is that, look, this is notice to the tenant that the court has awarded possession of the apartment back to the landlord. By law, you have 48 hours from the date of the service of the execution to vacate the premises. And if you don't, then the constable is coming back with a moving company, and the constable is going to change the locks to the apartment. He's going to remove the tenants from the premises, sometimes even physically remove them. And then again, all belongings are not only going to be removed from the premises, but they're also going to be placed in storage. Now, storage is a big question that landlords often ask, and I think it's misconstrued in a lot of cases. There are some upfront costs that the landlord is going to take a hit on, but they can assess it back to the tenant. And what those are is that the landlord, in order to proceed with this eviction and carry out the constable removing the tenant, removing the belongings, and changing the locks, they're responsible for the constable fees and they're responsible for the initial moving expenses. That means the landlord has to pay upfront the constable cost to serve, as well as the moving company's expense to essentially clear the apartment out. But under the statute, which is 239 section 4, those costs can ultimately be assessed back to the tenant. So you can put that back on the ledger. Whether we're able to collect it or not, if a tenant has a $10,000 balance and we're throwing $2,000 worth of constable and moving expenses on there, again, they're going to be responsible for it, but collecting could be a separate issue. But storage is going to be on the tenant. The statute 239 section 4 says that the tenant is responsible for monthly storage fees, and that those belongings are going to be placed in storage for a period of 6 months. If the tenant doesn't pay the storage fees or doesn't essentially pay the storage fees at the end of the day, there's a lien on it, which the storage company can ultimately pursue and enforce, which means that if the fees aren't paid, then the storage company can ultimately start selling off the belongings that are within that unit to satisfy what's owed to the storage company at the end of the day. Again, so the goal of any eviction is to get that execution, because that's our ability. That's the court order that authorizes the landlord to remove the tenant. Okay, so security deposits and last month's rent. It's all governed by statute, and these have to do with residential tenancies only in Massachusetts. Commercial tenancies aren't subject to these super strict requirements. So again, I want to make that clear. This only applies in the residential context, but it's really where tenants are able to raise defenses that can either hit the landlord, in the pocketbook monetarily, or gives the tenants defenses to raise in any sort of eviction. So at the outset of a tenancy, a landlord can only require the tenant to tender 4 things up front. So that's first month's rent, last month's rent, a security deposit, and the cost to purchase and install new keys to the apartment. Essentially, we just want to make sure that the old tenant doesn't have the new keys, so the landlord goes in, swaps the locks, and whatever that cost is can be charged back to the tenant. If it's not one of those 4 things, then it is illegal to charge a tenant for anything else. And common examples include the landlord's broker fee. This is actually a new law in Massachusetts. It became effective in August 1st of 2025. Prior to that, while I still think it was a violation of 186.15b, it was a common procedure to have the tenant pay a broker's fee at the commencement of the tenancy. Again, because it's not one of those 4 things, I think that was likely a violation of this, but now there's a statute which makes it crystal clear. So if the landlord incurs a broker's fee to find a tenant to rent the apartment, then the tenant bears that expense. He can't charge that broker fee onto the tenant. Now, if the tenant has their own broker, then they got to pay their broker. They hired their own real estate agent or broker to go find them an apartment. So, they have a separate agreement between those 2 parties, and the tenant will have to pay that. But bottom line is that the landlord can't require a tenant to pay his or her broker fee as a condition to renting the apartment. Similar illegal fees are pet fees, move-in fees, credit check and applications fees. And this is, a common issue or complaint that are raised by property managers or landlords, essentially saying, we're going to incur all these fees in order to process the tenancy or look at their application. Shouldn't we be reimbursed for those expenses? And the answer is that unless you can factor it into the rent, then it's a violation of the statute. And as we'll see, if you violate the statute, the defenses are pretty severe. So for last month's rent, if a landlord is going to require that a tenant pay last month's rent prior to the commencement of the tenancy, again, that's allowed because it's one of those four things, but the landlord has to provide the tenant with a receipt within 30 days, which notifies them that this is the amount of rent that they collected, this is the date that I received it, it's intended application as last month's rent. So you either note that on the check or you note that on the ledger. The name of the person receiving it, it's going to be your landlord or the property manager or whoever accepted it on the landlord's behalf. You got to have a description of the premises, which is essentially just the address, and then a statement on there that's required by law, which says that the landlord is accepting this for last month's rent and that the tenant is entitled to interest that's paid on that last month's rent. So, unlike a security deposit, which we'll talk about on the next slide here, there isn't a requirement that you put last month's rent in a separate interest-bearing account, but yet the statute holds the tenant responsible for annual interest that's earned on that rent. So, quite frankly, what a lot of landlords and property managers are doing is that if they're collecting these two things, they're putting it in a separate interest-bearing account because, again, the tenant is entitled to interest. They're entitled to know how much interest and where it's located. So, in order to comply with that, that's how a lot of property managers are getting this done. Again, pretty similar for a security deposit, but again, the difference between last month's rent and a security deposit is that that deposit that's collected has to be placed again in a separate interest-bearing account, technically located within the state of Massachusetts. It's a common, again, complaint or an argument, and I get from landlords or property managers saying, "Hey, our office is in New Hampshire. Do we have to actually place it in a Massachusetts bank?" And the response is, well, that's what the statute says. I haven't seen a court or a tenant raise this issue as to, whether it's a legitimate defense to the eviction. But again, we can only advise you as to what the requirements under the law is and what the statute says. And what the statute says is that you got to place it within a bank that's located in Massachusetts. So again, like last month's rent, once you collect that security deposit, you need to give the tenant a receipt, which provides the name of the bank, the location, the amount of the deposit, and the bank account number. And the bank account number is incredibly important. It's probably the information that tenant attorneys are looking at all the time, is so that the tenant has the right to see where the funds are being held, to look that annual interest is actually being incurred on that security deposit. And they also want to confirm that the landlord isn't commingling the funds. So again, super important that if a landlord or a property management company has 10 different tenancies within a building, there needs to be 10 different accounts that are open up for that. And that's because you can't commingle the funds. So the tenant needs to be able to see that their security deposit and their security deposit alone or their last month's rent is in a separate interest-bearing account. Again, and that the purpose of keeping it in a separate interest-bearing account is to ensure that they're entitled to annual interest earned on it at the end of every year. And what the statute says is that you actually have to pay that out to the tenant. It could be pennies at the end of the day. We're talking about, 6, 7 cents that accrues on $1,500 worth of last month's rent or security deposit that's being held. So the statute allows tenants to receive that in one or two ways. So the landlord could technically send the tenant a check for that 7 cents, 10 cents every year, based on what they're owed and what interest accrued on the last month's rent or their security deposit. But what most landlords opt to do, but you got to request the tenant's permission first, is to essentially knock it off the next month payment. So if the tenant is staying for another year and they're entitled to annual interest earned on the rent, then what the landlord will do is reduce that 13th month rent by the 6 or 7 cents or whatever it is owed. And if you do that, it does comply with the statute. Okay, statement of conditions. So if you're collecting a security deposit within 10 days of the commencement of the tenancy, the landlord must give the tenant a statement of the conditions of the premises. And usually, from the landlord's point of view, it's pretty simple. says that the apartment is in clean and sanitary condition with no known repairs. And then once the tenant gets that, then the tenant has 15 days in which to oppose that or write conditions on that statement, which, essentially says that, the fridge handle was broken, or there's a hole in the screen or the window, or there was the scratches on the floor, anything like that. And that's because what the law says is that a landlord can't deduct from a security deposit things that are noted on the statement of conditions unless it was repaired prior to that time. So there's a statutory notice that you have to include in the statement of conditions. Again, this is what the statute says. I haven't seen a judge or any tenant attorney raise the issue that, look, they gave me a statement of conditions, but it didn't include this specific language in there. What's really important is that, look, if a tenant raises these issues on a statement of conditions that are legitimate, meaning that, there are scratches on the floor, or the fridge handle is broken, that you can't deduct that at the end of the tenancy, or else, again, you're going to be in violation of 186.15b. Okay. What can a landlord deduct from a security deposit at the end of the tenancy? And, it's limited to these things. So within 30 days after the expiration of the termination of the tenancy, meaning when the tenant vacates, the landlord can apply the security deposit to unpaid rent or use and occupancy, meaning the outstanding rental balance that's owed, increase in real estate taxes. So some lease agreements, especially, I mean, again, this doesn't apply in a commercial context, but commercial landlord tenants are responsible for real estate taxes. But to the extent that a residential tenant may be, some tenants are required to pay whatever the increase is over the term. If that's not paid, the security deposit can be applied to that. And then probably most important is any damages to the apartment. So if there's damages that are beyond normal wear and tear, again, rug's a little scuffed up, the fridge isn't super, super clean, but if there's legitimate repairs that need to be made, talking about holes in the walls, broken windows, damaged doors off the hinges, things like that, then if that damage does accrue in the apartment during the tenancy, then the landlord can deduct whatever the costs were to repair it, provided that they notify the tenant within 30 days and they provide them proof as to what their costs were. So we're talking about invoices from contractors, receipts from Home Depot, cleaning costs that are above ordinary wear and tear. That needs to be provided to the tenant within 30 days, because if you fail to adhere to that, then again, we're talking about liability under the Massachusetts Consumer Protection Act. Again, kind of what I said earlier, the statement of conditions, if you can't apply a security deposit to any of the things that the tenant raised at the beginning, if they're not addressed, or things that were in the apartment that the landlord knew about prior to when the tenant moved in. So those are unlawful conductions at the end of the day. Okay, then the process in which a landlord applies that security deposit. Again, you got to do it within 30 days and you can only make those lawful deductions. But if the security deposit isn't deposited in a separate interest-bearing account, statute says that you have to return the security deposit in full. Again, if there's damages to the apartment and you don't provide the tenant with a list of what those damages are and backup receipts and invoices within 30 days, say you do it within 60 days or 45 days, technically under the statute, you have to return the security deposit in full. Again, one of the other violations of the statute is that, say that you're holding a security deposit for $2,000 and the apartment's in good shape, but they owed you $1,000 at the end of the time. You can certainly take that $1,000 and apply it to the outstanding rental balance, but you have to return the remainder within 30 days. And if you fail to do so, it's a violation of the Consumer Protection Act. So I know I've said that a few times during this. So Massachusetts Consumer Protection Act, it's Chapter 93A. And what that statute does, it prohibits landlords from engaging, or anybody who engages in commerce, companies, landlords, contractors, from engaging in unfair and deceptive trade acts or practices. And what that means is that if in the landlord context and for security deposits, if you fail to process the security deposit in the way that the statute is talking about, or if you fail to return it when you weren't supposed to, or you don't provide the invoices for damages to the apartment, that the tenant is technically subject to triple damages plus their reimbursement of their attorney's fees if they got a lawyer. So again, in the example that's on the screen, if you have a security deposit that's $2,000 and you fail to return it or you didn't apply it in the way that you were supposed to, like the statute says, the tenant could be entitled to get an order from a judge for $6,000 plus their attorney's fees because that's three times the amount of the security deposit. And again, this is a super, super common tactic that landlords raise as a defense to any eviction. Common issues with security deposits. These are questions and concerns that we get um, a lot. So, what if, you just had an awful tenant? What if there's an outstanding rental balance and that there's damages owed for, or there's repairs that need to be made in the apartment? Essentially, you don't know what to apply the security deposit to. How do you process it? And it's up to the landlord how they want to do that. There's no specific order. My recommendation is that tenants often really only have an argument to the application of the security deposit, so long as it's done timely in accordance with what the statute says, is that um, if there's repairs that they question, their argument is going to be that this is really just ordinary wear and tear. I know you replaced the rug and you want to charge me $2,000 for it, but I was in the apartment for 5 years. That might just be considered ordinary wear and tear. Whereas if it's clear that the tenant didn't pay their rent, then that's crystal clear. They either didn't tender payments to the landlord or not. So if we have an outstanding balance reflected on a rental ledger, my recommendation is, look, let's apply that, make you whole at the end of the day from a rental standpoint, and then we can talk about whether or not you get a legitimate claim to go seek, damages from the tenant for any repairs that needed to be made to the apartment. So again, um, there's no specific order in which you need to apply it in, but what's your better argument here? It's typically non-payment of rent most of the time. Okay, what if there are multiple tenants who she returned the security deposit to? Again, not really the landlord's concern. The security deposit is security for the tenancy. If there's two tenants, write the check to one of them, send it to them, and have them figure it out. It doesn't matter if tenant one paid $1,000 and then tenant two paid another $1,000. You don't get involved into how you're going to split that. Again, let them figure that out. Um, can a tenant apply the security deposit to rent during the lease term? No, you can't. And that's because, like we just went through, the statute talks about the specific deductions you can make. So it can be applied to non-payment of rent, real estate taxes, or damages 30 days after the expiration of the tenancy. So if a tenant wants to use their security deposit in the middle of a term, number one, it's not allowed under the statute. And number two, that's just a bad sign. So if there's an outstanding rental balance owed, terminate the tenancy for non-payment of rent, and they're either going to pay you in full to avoid an eviction. Maybe they'll apply to RAFT and get you some rental assistance. But again, you can't apply the security deposit or last month's rent during the midterm. So that's Landlord-Tenant 101 in a nutshell. I see we have a couple of questions here. Again, if there's anything that I didn't touch upon exactly, please fire them in the chat and I'll see if I can answer them. We do got some time here. So the first question is, has there been an increase in tenants not paying rent due to the recent economical climate, layoffs, etc.? I would say yeah, and I think we see our firm is particularly, susceptible to that because we do a lot of condominium lien enforcement and foreclosure work. And in my experience, tenants are the first to fall. So yes, it's certainly better than COVID times. So during the pandemic, evictions were through the roof, but without a lot of relief because there was an eviction moratorium at the time, which prohibited you during the pandemic from evicting for non-payment of rent. There were other ways around it. You could terminate tenancies for cause due to detrimental conduct. You could terminate tenancies at will. But I think to answer that question, it's still an issue, but I don't think it's as bad as it has been. Okay. Second question. As a landlord, am I required to have an attorney draft a notice to quit or an eviction notice, or is it acceptable for me to prepare and serve the documents myself as long as they meet state law requirements? Yeah, there's no requirement that an attorney be involved. Quite often, housing court is filled with pro se litigants from both the landlord and the tenant perspective. But it kind of goes back to the point that I was talking about, is that you got to adhere to those statutory requirements because if there's any defect in the notice to quit, if there's any holes, if you don't include any statutory language, or the address is wrong, or the outstanding rental balance includes legal fees, or anything like that, it gives the tenant an avenue to oppose your eviction. So my recommendation is, obviously, I'm a lawyer. I want you to have me draft the notice to quit, but it's for that purpose. By the time we're in court, we've already spent so much time and money to get to this point. We don't want a technicality to eliminate the landlord's ability to evict. So again, the answer to your question, no. You don't need a lawyer to draft it, but it's highly recommended so that you're adhering to all the statutory requirements. A couple more here. How long do the raft applications usually take? They're getting a lot better. Again, well, the further we get away from the pandemic, the quicker that they're getting. During peak pandemic and the years after, it was taking 2 months to process these things. But they've gotten a lot quicker. I think they're turning them around in 3 or 4 weeks by now, maybe even 2 weeks in that case. And that's seen in the housing court as well. So if I'm in on a summary process action and we're scheduled for trial, but we get notice that the tenant has applied for RAP. The court's continuing it for 2 weeks, and that's because they're turning around these RAP applications pretty quickly. So they could be done in 2 weeks, but again, it's all dependent upon how quickly is the landlord or the tenant filing the documentation or answering the questions that they need to make. So if that's done, days after the questions are asked, I think they can turn it around within 2 or 3 weeks. Okay, a couple more here. What is the minimum requirement of payment for storage that a landlord has to pay in order to remove the tenant and obtain possession? I don't know if there's a minimum requirement. I know there's regulations that touch upon this. I just never had to deal with it. But it's from the landlord's perspective, it's whatever the constable costs are and the moving company's fees. That's what we're dealing with here. Again, storage is on the tenant. Um, I'm not sure if the moving company requires payment of that outright. It might be a month or so, but it's whatever. It's all going to be made clear at the outset is the answer to the question. So typically when I'm working with a constable and a landlord that's carrying out an eviction, then what we're going to figure out at the outset is that, okay, eviction is scheduled for Friday at 12 p.m. So once I get that notice from the landlord, one of the things, or from the constable, one of the things that I'm confirming with the constable and the landlord is how much does my client need to bring up front in order to get this done. So they typically take a credit card or a check, but that check is going to be for the constable fees and the moving company's fees. So that should all be made clear at the outset. We got a condominium type question, so I'll take a few more here because we do have an hour and we're running up on that. Can a private condominium association charge move-in or move-out fees to cover the cost to associations, the condo staff's time used by the tenant to coordinate and assist with the month? So if the association is charging move-in and move-out fees to the unit owner, you're not going to run into an issue with the unlawful deductions or the unlawful charges under the security deposit statute. And that's because those are in situations where the landlord charges the tenant directly for first month's rent, last month's rent, security deposit, and then the lock and key change. So long as the association is charging the owner directly rather than the association charging the tenant directly, you're not going to run into an issue with that. Sometimes unit owners will try and argue that, look, you can't charge me this based on the provisions of that statute, but they're not understanding the privity of contract there. Essentially, association and tenant don't have a lease agreement, don't have a tenancy together. So the association could still charge the unit owner move in and move out fees. But again, like MEEB always says, it's best that those provisions are in your documents just to make sure that they're enforceable at the end of the day. Okay, I will take two more here. If the commercial tenant is in New Hampshire, but we operate in Mass, can the last month's rent or security deposit be held in Mass in a separate account? Again, I don't know the statutory regulations with respect to processing security deposits and last month's rent in New Hampshire. The only thing that I can answer if it's vice versa. Technically, in Massachusetts, the security deposit and the last month's rent needs to be held within the state. But again, I think we're really nitpicking as a tenant if we're making those arguments. Usually there's a bigger issue at hand. So, all I can recommend is that if you contact our office, I can look up what the New Hampshire regulations are. But again, in Massachusetts, while that would be a violation of the statute, I don't know if it warrants to removal or dismissal of a summary process action or assessing damages to the landlord for a violation of that. Okay. I will take, all right, a lot of people want copies of the slides. Okay. Is there a way to accept rent electronically, i.e. Venmo, Zelle, etc., where I can preserve the right to not accept past due rent in case of an eviction? So, yes, so long as it's in your lease agreement, so that my recommendation is usually that, if the tenant is able to accept rent, so long as it's not cash, I say to try and work with them because if I'm in on a non-payment case and we have $5,000 of worth of rent that's owed, but the tenant's coming in with receipts saying, "Hey, I tried to send it by Zelle, I tried to send it by Venmo, and he won't accept it." That's it's just bad optics in front of a judge at the end of the day. So if you can't accept payment like that, I recommend that you try and work with the tenant. But again, so long as you're not incurring additional fees on your end. Um, but where I can preserve the right to not accept past due rent in case of an eviction. So I know a lot of property managers use AppFolio or certain software rental applications like that. I think there's a mechanism in which you can not accept rent at one point, but ultimately, I'm not typically worried about accepting rent, especially when you're dealing with a termination of tenancy at will, because even if the tenancy at will has been terminated or a non-renewal of tenancy, landlords can still accept payments when they come in, so long as it's made clear that they're accepted for use and occupancy only. And the reason behind that is that landlord-tenant tenancy at will uh, argument that we've been talking about is that by operation of law, if there's no lease agreement or a tenant tenders rent after their tenancy has expired, they're considered a tenant at will or a month-to-month tenant. The way you get around that is that you accept it for, again, use and occupancy only, and that ensures no new tenancy is created, which would require you to start the eviction process again. So I think that's all the time that we have. This was scheduled for an hour today. Again, my contact information is on these slides, which are going to be circulated to everybody who attended today. So feel free to give me a call with regarding residential tenancies, commercial tenancies in Massachusetts. Again, our firm does handle New Hampshire matters as well, and if there's anything that we can do, we're happy to help. Appreciate everybody joining today, and again, we'll talk soon. And if we don't see you, happy Thanksgiving. Take care, everybody.